I'm going to tell you, firstly, what the advantages of a claim based upon a breach of a fiduciary duty would be, when such fiduciary duties may be owed, what the core duties of a fiduciary are, briefly, and then a line of case law that, practically speaking, explores how the courts approach whether or not a fiduciary relationship exists or not. I'm not going to be giving chapter and verse on everything about fiduciary duties. I'm sure you'll be grateful to hear. I'm just trying to give you a starting point as to when exactly a fiduciary relationship arises. So firstly, why would you frame a claim around fiduciary duties? Well, firstly, I'd say it's a reasonably flexible cause of action. It gives its application to a wide range of factual circumstances. It's likely to be readily made out in a fraud context, for example. If somebody owes a fiduciary duty and practices a fraud on another, then apart from any liability that may arise in tort or otherwise, it will almost certainly be in breach of a core duty of loyalty that a fiduciary would owe. And a claim would arise by result of that breach, irrespective of the fact pattern of the claim, that could give rise to a cause of action in deceit. Secondly, the establishing of a breach would give rise to a range of equitable remedies that may not be available in other circumstances. For example, not just your usual compensatory remedies that are similar to common law damages, but accounts, inquiries, and obligations to return profits. Thirdly, benefits obtained as a result of the breach of fiduciary duty, including, as it's now established, bribes and secret commissions, will be held on constructive trust for the principal. So that gives the ability, for example, to recover those benefits in priority to other creditors if the fiduciary goes insolvent, as well as the rights to take the benefit of any appreciation in value of that benefit and to trace them and follow them into the hands of third parties and into substitute assets. Fourthly, the ability to set aside transactions if, as a result of the breach, that transaction is entered into. You have the ability to seek that to be set aside. And then finally, the ability to seek equitable accessory liability claims against third parties. For example, those who have dishonestly assisted in that breach or have unconscionably received money or assets transferred as a result of that breach. So, fundamentally, what I'd like you to remember, if you forget everything of this talk, what I'd like you to remember is the first quote that I've set out under this heading on the handout, which is that a fiduciary is not subject to fiduciary obligations because he is a fiduciary. It is because he is subject to them that he is a fiduciary. It is the obligations that arise first, not the relationship. It's an objective question. It's not dependent on a party appreciating the position they're in, the obligations they owe. It is a question that is to be established objectively. And I've listed what are known as the settled categories in the handout, the five in particular and very notable categories that where those relationships exist, there is a strong presumption that that relationship involves fiduciary duties. But such duties can be found outside of those settled categories where the facts and circumstances of the relationship justify that. And that is a factually sensitive inquiry. Now, in particular, when we're looking in a commercial relationship, the terms of any contract or arrangement between those parties is going to be extremely important to examine. It's the relationship that is defined by that, usually by that contract. And so how the parties allocate and define the scope of their responsibilities will be relevant to this question. Not only do you have to establish whether such a relationship would justify a fiduciary relationship, a duty being imposed. The question is then, to what extent is that duty imposed? Are they What is the content of that duty, and to what part of the relationship does that duty pertain? And so the advice is really to proceed with real caution. There is no blanket rule. You can only state such rules in broad terms and apply those rules in particular circumstances to each case. And I've described in the handout the useful yardstick that anyone should really be starting from, which is whether or not somebody has either expressly or by implication agreed to act for or on behalf of somebody, which gives rise to a relationship of trust and confidence. If somebody assumes to act in relation to their property or their affairs, and often their financial affairs, that is its classic application. And you can apply that test to the settled categories and make sure that that works. For example, a trustee is appointed to hold property which belongs beneficially to the beneficiaries, and they are required to therefore deal with that property and are trusted to do that. An agent agrees to act on behalf of the principal and often assumes a power to alter its legal position, again, managing its affairs. And a director takes office and is responsible for the management of a business and the controlling of its assets, again, assuming control of property and affairs. But relationships with trust and confidence aren't necessarily enough, and the example that can be given here is the employment relationship. An employee is not necessarily a fiduciary, despite that relationship of trust and confidence. What you must also have is the principle of self-denying loyalty, in that the fiduciary is expected to subordinate their interests to that of the principal and not benefit from that unless the principal has agreed freely and with full information about this benefit to consent to that. So there could be a number of circumstances that could point to a fiduciary relationship. The existence of a relationship of trust and confidence, an inequality in bargaining power, an undertaking to perform a task in the interests of another, the ability for one to alter unilaterally or exercise a discretion in respect of the rights of another, or a vulnerability or a dependency on the part of one that causes that reliance on another. Importantly, a fiduciary relationship, and in particular the principle of self-denying loyalty, is often at odds with the usual commercial relationships. But again, it's for each individual circumstances to be analysed as and when they arise. They may be, that presumption may be displaced, and we will see case law where that is the case. So briefly, what are the core duties? Well, the first is the no conflicts rule, and the second, the no profits. These are the uncontroversial ones at the very least. There has been significant academic commentary on exactly what constitutes a fiduciary duty, but I think these are the two that we can't really argue about. The first is no conflict. So that's the duty not to put oneself in a position where your duty conflicts or may conflict with another's personal interests. Now, the rule is concerned with deterrence, so it's not needed to show any other breach as well as the conflict. The actual self-interest in and of itself is the breach. Whether or not that dealing is beneficial to the principal is irrelevant. No bad faith is required. And the rule often is split into two particular types of conflicts, and that's self-dealing and fair dealing. Again, briefly, self-dealing involves being on both sides of the transaction. So, for example, if a fiduciary wants to purchase property held on trust, and it's that property that the fiduciary controls in their fiduciary capacity that they want to purchase. If that occurs, that the principal is entitled to avoid the sale as of right, regardless of how fair or advantageous it is. Now, fair dealing is slightly different. That arises where a fiduciary wants to enter into a transaction with the principal, which arises as a result of the fiduciary relationship, such as where a trustee could want to purchase a beneficiary a beneficial interest of a beneficiary. So the fiduciary in that situation needs to show that they took no advantage of the position, that full disclosure was made, the transaction was fair and honest. If that's not shown, then the principal can have that transaction set aside. The second duty, again briefly, is no profit. So this is the duty not to make an unauthorised profit from that position as a fiduciary or from property controlled or information obtained in a fiduciary capacity. Acting honestly or in bad faith is irrelevant. It's irrelevant whether it's open or in the best interests of the principal. No loss needs to be shown to be suffered. It's the risk of influence on the loyalties of the fiduciary that is relevant. Again, there is a deterrent effect here, and hence why the receipt of a bribe or a secret commission is a breach generally of that no profit rule. The question often arises is whether that profit has been fully consented with the informed consent of the principal. And the four cases that I want to briefly discuss surround the relationship of a broker and the receipt of secret commission. And they culminate in the more recent case of Wood and Commercial First Business. And those who have had an opportunity to see my talk most recently on the Newcastle Commercial Litigation Conference will see that I discussed these cases in a different context, in the context of the bribery cause of action, but they're very useful to determine the test and how the test of fiduciary relationships actually applies. So it's useful to approach them from that different angle. So the first case is Herstanger, and for those who don't know the facts, briefly, the borrowers were in mortgage arrears. They potentially faced possession proceedings. They needed a loan, so they got a loan from a broker through a third-party lender in the non-status lending market, and that lender told them that in certain circumstances the broker would be paid a commission for the introduction. Now in that case a commission was paid, and the borrowers were not told about this specifically, not told about the amount of that commission. So when the borrowers defaulted on that loan, the lender sought possession proceedings and they sought to avoid that loan agreement and rescind it on the grounds of the secret commission. So knowing those facts, you'll have seen the conclusion is that the Court of Appeal held that that was an obviously fiduciary relationship. And that was obviously fiduciary because they said that the borrowers had retained the broker to act as their agent, firstly. They had been required to act loyally and not put themselves at conflict of interest. But they had been put at a conflict because they had an interest, the broker had an interest in getting a deal from a lender that gave them the biggest commission possible. But the reason they had been retained by the lender was to obtain the best deal for them. And that conflict had led to a breach of that duty. There was then an exploration as to whether or not fully informed consent was given, and it was really Herstanger that gave rise to the principle of half-secret commissions, whereby the disclosure of the existence of commission but not the particulars was enough to negate secrecy, but not enough for informed consent. And that was, again, in the particular circumstances of this case, where the borrowers were held to be vulnerable and unsophisticated. They were seeking a loan from a more difficult market to obtain finance. They were not able to access traditional routes, and so they had that vulnerability. And in that circumstance, that duty can only be avoided where full information about the particulars of that benefit is given. And so that case is useful to establish not only how the relationship arises, but how the duty is also then defined. And again, it's to do with the particular circumstances of the case. There's no blanket rule. So the next case is McWilliam. And again, in this case, the borrowers were seeking a loan from a lender. They were wanting to consolidate debts. And in that loan, PPI was included. They wanted to recover that PPI commission after that loan had been repaid. and two of the issues on appeal were whether the broker firstly owed fiduciary duties, and if so, whether they had been breached. Now, it was Lord Justice Tomlinson who said that Herstanger really bound him to determine that a fiduciary duty had arisen. That relationship did exist. So despite the fact that in this case the transaction was non-advised, there was still that relationship of trust and confidence, whereby the borrowers had placed their trust in the broker to obtain the best deal for them and act in their interests and not in their own. A particularly interesting outcome from McWilliam is that Lord Justice Tomlinson noted that it's possible in matters of finance to display reasonable competence in handling relatively straightforward transactions and yet lack what would ordinarily be called financial sophistication. And so what was really analysed here was, to the extent to which informed consent was needed, what was the vulnerability and sophistication of that particular person in that particular relationship. And again, in that case, it was held, despite them being more sophisticated than those that we've heard about in Herstanger, there was still that obligation to provide further information for consents to be fully informed, because on those facts, that duty hadn't yet been avoided. And so in that circumstance, there was a duty to disclose that commission, and it had been breached. Now contrast that with a more recent case of Medstead, whereby a broker had introduced wealthy and experienced investor clients who were interested in trading contracts for difference to a financial services institution, and that was in return for a share of the commission to which that institution would charge to those clients. In that case, the Court of Appeal held that the relationship was fiduciary. That's because the broker had impliedly represented to the investors that those terms were competitive. And so those investors had reposed trust and confidence in that broker. However, when the court was analysing the scope of those duties, they said that that obligation was more limited. The investors knew the commission existed. They knew the financial institution was going to charge that commission. But they didn't know precisely how much. The investors knew that there was going to be receipt, but not exactly how much. The Court of Appeal said that in that case, that was enough in the circumstances of them being wealthy and experienced. They didn't need to know the particulars in that case. And so there was no breach of duty because informed consent had been given. Again, going back to whether or not a fiduciary relationship exists, it's not simply whether or not that relationship exists and therefore the blanket rule applies. It's once it exists, what is that scope of duty? That requires further analysis. The final case to refer to is Wood and Commercial First Business. Now, this was a conjoined appeal on very similar facts against the same lender. Now, the borrowers had mortgages against their properties in this case. The broker had received commission from the lenders which hadn't been disclosed. And upon the borrowers defaulting, the lenders sought enforcement proceedings, again, very similar to Herstanger. When the borrowers counterclaimed for rescission and recovery of those payments as secret profits, in the conjoined appeal, the Court of Appeal were considering to what extent is a fiduciary relationship needed to engage the law of bribery. Now, what they said that it's unnecessary and potentially misleading to inquire as to whether the relationship is truly fiduciary. The only real question is whether that agent owes a duty to give information, advice, or a recommendation on a disinterested or impartial basis. That's enough to engage the law of bribery. In that case, a fiduciary duty, whilst the Court of Appeal found that the relationship was fiduciary, it wasn't actually relevant. And so whilst the court are engaging in factually specific analysis of whether or not a fiduciary duty exists, whether or not that relationship is enough to give rise to fiduciary duty. There is a sense, I think, from Wood that the court is not wanting to engage in significant discussion surrounding that and is more interested in the fundamental relationship, whether or not the relationship gives rise to the claim of bribery, for example. And I get a sense that courts won't want to undertake lengthy analysis in each case. And that's really born, I think, from, as well looking at the previous 3 cases, the actual existence of the duty wasn't discussed in great detail. It was the scope of that duty. And that really, I think, should be the focus. It's not simply whether or not the relationship arises, it's to what extent is that duty defined. And that, again, that very much depends on the facts of each case.